this act, if a child custody dispute involves a child who is conceived as a result of acts for which one of the child's biological parents is convicted of criminal sexual conduct, you want to award joint custody to that individual. The second says that notwithstanding other provisions of this act, if an individual is convicted of criminal sexual conduct and the victim is the individual's child, you won't award joint custody. As I read this bill, because it comes later in time and it makes no reference to those sections, it would presume that joint custody is appropriate under those circumstances. I want to ask you, one, whether you agree with that interpretation, and I think it's something for us all to worry about as we review this legislation, because I don't think anybody in this room would seriously argue that constitutionally we have to award joint custody to individuals under those circumstances. I certainly wouldn't want this bill to go forward and make that horrible mistake as it's enacted by this legislature. And I also want to comment on that constitutional argument we've been hearing over and over again. I believe that there is a constitutional right for parents to direct the education and upbringing of their children. But I don't think it's ever been interpreted as saying that you could remove parental rights or that in a divorce action, a determination of the best interest of the child is the best constitutional course to follow.
I think that the relationship between parents and children is an important relationship and does have constitutional protection. That protection has never been construed to mandate equal physical time. And I don't think it has ever mandated that children be treated as property. As to your other question about whether this law would overrule the prior, it would mandate equal physical time with the children. The question for the other parent they would have to then show that the criminal sexual conduct was unfitness by clear and convincing evidence. So it would be up to them to, the burden of proof would shift to the parent trying to prevent that placement, and they would have to go forward and show that there had been criminal sexual conduct and that it had, and that was unfitness by clear and convincing evidence.
If I could follow up.
Absolutely.
I just want to ask another question, because the Section 6A, the section that is proposed to be amended, already provides in custody disputes between parents, the parent shall be advised of joint custody at the request of either parent. The court shall consider an award of joint custody and shall state on the record the reasons for granting or denying a request. And, of course, using the best interests of the child as the guide. It also says that if the parents agree on joint custody, the court shall award joint custody unless the court determines on the record, based on clear and convincing evidence, that the joint custody is not in the best interest of the child. So that is a greater standard to not award joint custody if the parents agree.
And frankly, I can't imagine a court overruling the parents' agreement. Because even if the court were to say, that's not what I'm ordering, the parents will just do it.
Chair, just a very quick statement. I was contacted by social services in various counties and advised there are some judges still granting custody to parents who have been convicted of sexually assaulting their children. In fact, I have a bill in another committee addressing this, and I would certainly support an amendment to this bill in that manner.
Thank you, Representative. Other questions? I do have one. You referred, Mr. Weichman, to the issue of the standard. This bill would call for a presumption. You would agree that it could be rebutted. If the standard were changed to something other than clear and convincing, maybe preponderance, then you would support this bill?
No. Preponderance of evidence of unfitness?
Yes.
Yeah. No. The unfitness standard is just the inappropriate standard, whether it's by preponderance or clear and convincing.
So the argument, just hypothetically, that this would somehow prevent important information about names that were being called by the parent in clear and convincing isn't going to be cleared up by preponderance.
Right, it just changes this changes the focus. Instead of looking at what's best for children, this says you automatically divide the time 50-50. And our view is, no, the focus in these cases should always be what is best for the children.
Thank you very much.